So, yes, once again, thank you for joining us this afternoon for Neighbors and Neighborhoods, a discussion on steering in fair housing. Before we jump into that, we'd like to take care of some housekeeping and acknowledge, first and foremost, the Michigan State Housing Development Authority, or MISTA. Without a generous grant from whom we would not have been able to offer this training free of charge. Uh, this training session will be recorded. So if you've got an issue with being that being the case, my apologies. Hop on out. Um, However, if you do have any questions, you can go ahead and put them into the question and answer box here on Zoom, and we'll address as many as we can at the end of the presentation, time permitting. And finally, just a disclaimer, we here at the Fair Housing Center of Southwest Michigan are not attorneys, and as such, this training does not constitute legal advice. Its contents are presented for educational purposes only. So before we jump into the details here, a little bit about the Fair Housing Center of Southwest Michigan. Here at the Fair Housing Center, we promote integration and work to eliminate housing discrimination. And we do that through education, advocacy, and enforcement of the fair housing law. So when we say that we promote integration, we mean that in pursuing our mission, we aim to reverse the segregatory effects of societal decisions. When we say we work to eliminate discrimination, we mean that we aim to remedy the actions of individuals. And so our three tools for this, as I said, are education, advocacy, and enforcement. And we're intentional about that ordering. So the Office of Housing and Urban Development, also called HUD, estimates that annually there are 4 million occurrences of housing discrimination. Only about 11,000 of those go reported. And so we figure if we can educate well enough, we can ideally eliminate housing discrimination before it begins. Um, However, education can also encourage people to recognize and report housing discrimination as it happens, after which we can advocate on their behalf and work to secure justice through enforcement of the fair housing law. So, what then is fair housing? Fair housing is the right to not endure discrimination in housing and housing services. And so those services include, but are not limited to, renting, selling or buying, advertising, financing, insuring, or appraising a home. And the goal of this session is to give you information that can help you protect the members of your community. Much of the training is designed around a tenant's perspective, but it's important that housing providers also understand the fair housing laws and their responsibilities therein. Of course, you don't need to memorize everything today. You don't need to leave here as a fair housing expert. If you have any questions, you can always call us at the Fair Housing Center uh, if you have any questions. So, what is housing discrimination? Housing discrimination is when someone is being treated differently than another similarly qualified person in a housing related transaction. And importantly, here, similarly qualified person means someone who has the financial means to enter into a housing transaction. So if you're having your choices limited or services are being provided differently, that can constitute discrimination. But what's important is that discrimination needs to relate to a person's membership in one or more of the protected classes. We'll get into that. So another way to put it is there's a formula for determining whether an action meets the criteria to be considered housing discrimination. And that formula has three elements. They are a covered dwelling. So very nearly all residential constructions will be covered by the fair housing law. Uh, the person involved needs to be a protected person. That is, they need to align with one of the 7 federally protected classes, which are race, color, religion, national origin, sexual orientation and gender identity, family status, and disability status. State and local governments can add to, but never remove these protections. And each of these protections were won over time. So finally, um, the practice at issue needs to be unlawful. And that's pretty broad, but any practice that treats differently any member of a protected class during any part of the housing transaction, whether through intention or effect, is unlawful. Uh, so the first element is a covered dwelling. So what are those dwellings? You can see here a partial list: apartments, transitional housing, college dormitories, single family homes, or excuse me, mobile and manufactured homes. Basically, the point is that a dwelling under fair housing law is to be construed as broadly as possible. So there are very limited exceptions, but all places of residence that are not strictly commercial ventures, such as a hotel or a motel, are covered by the fair housing. Furthermore, all aspects of the housing transaction are covered. So not only does the Fair Housing Act prohibit kicking a person out of a rented apartment because of their nation of origin, it would protect that same person from nation of origin discrimination in the rental application process, in the process of securing a loan for home ownership, in home appraisal, any part of the housing transaction. We've had some questions before, so just to bring up mixed use dwellings, such as Airbnbs or long term hotel stays, they can present an edge case. So, what that means is how the fair housing law applies is largely based on primary residence. So, in the case of hotels, for instance, uh, the Fair Housing Act seldom applies because a guest in a hotel usually has a primary residence elsewhere. In homeless shelters, however, even though the stay could be as short or shorter than a hotel stay, fair housing does apply because no other primary residence exists. Now, these are the covered dwellings. There are some exemptions. So those limited exemptions are religious organizations, the Mrs. Murphy Rule, and Senior Designated Housing or Housing for Older Persons Act housing. And so, yes, in limited circumstances, the Fair Housing Act will make exceptions for housing operated by religious organizations. That is to say that religious organizations are allowed to give preference to people of the same religion if the housing is non-commercial, uh, which means that rent is not being charged, and the religion doesn't itself discriminate based on race, color, or origin. So, for example, a Catholic organization can legally limit occupancy or at least give occupancy preference to other Catholics in a batch of apartments at a property that they're not charging rent. Uh, the Mrs. Murphy rule, as it's known, covers owner occupied housing, and that exempts small holding housing owners from the fair housing. So federally, a residence that comprises four or fewer units or dwelling units that is presently occupied by the owner or the owner's immediate family member or members is exempt from the fair housing law under the Mrs. Murphy rule. Each state has its own particular version of the Mrs. Murphy rule, and here in Michigan, um, it's the same as the federal rule, but we restrict it even further to two or fewer units, so a duplex or less. Uh, Finally, the housing for older persons is exempt federally from only family status protections and is separated into two categories. And those categories are housing for persons 55 and older and housing for persons 62 and older. Uh, there are a few rules that apply to those types of housing as well. In a housing meant for persons 55 or older, 80% of those units need to be occupied by at least one person who is at least 55 years old. The terms, regulations, and advertisements pertinent to that dwelling need to clearly state its intent to operate as housing meant for older persons. Those same things apply, except housing for a person 62 years old or older is a little stricter in that 100% of those units need to be occupied by at least one resident who is 62 years old or older. So in both cases, though, there are further exemptions to those rules that allow caretakers, employees of the dwelling to live there, regardless of age. Usually, disabled persons can live in either class of dwelling, regardless of age. Uh, but regardless of these limited cases, it is never permissible to discriminate in the advertisement of any part of the housing transaction. So, We've looked at the dwellings pertinent to the fair housing law. So, what are these protected classes? There are 7 federal, and here in Michigan, we have um, 4 main ones that are added for housing purposes. Um, Before we dig into that, I'd like to give a brief note on language. Throughout the training, I'll use class, characteristic, category to refer to the protected classes. Uh, Protected class is the language that's within the fair housing law, but sometimes it just makes less sense to describe someone as being in the class of families with children, for instance. And so, for our purposes in this training, class, characteristic, category, they refer to these protected classes. So, when we say race, we mean that all races are included, and when we say color, we are referring to the color of one's skin. You know, a darker skinned person of Indian origin has the same rights as one with lighter skin. Uh, Religion includes one's membership or lack thereof in an organized religious group, as well as one's spiritual ideas or beliefs. National origin refers to the country where a person was born or from where one's ancestors came. Gender refers now to a person's binary gender federally. Disability includes physical, mental, and sensory conditions that substantially limit a major life activity. And family status covers the presence of one or more children under 18 in the household in a custodial relationship with an adult. And that custodial relationship, again, should be construed broadly. That includes a parent, a step parent, an adoptive parent, etc. Here in Michigan, we add a few more. Age is a protected class in Michigan, so that means individuals of any age, so long as they can enter into a housing transaction. Um, Sexual orientation and gender identity pertains to one's actual or perceived sexual orientation, as well as the identity, expression, or perception thereof. That includes one's relevant attitudes, preferences, beliefs, practices of their gender, irrespective of its relation to their sex assigned at birth. Marital status protects people whether they're single, married, separated, engaged, widowed, divorced, and in some local jurisdictions, just cohabitating. And finally, source of income protections are the most recently added, and those protections prohibit discrimination based on where a prospective purchaser or renter gets their money. So that's something like Section 8, veterans benefits, Social Security. Um, as long as you've got the money, it doesn't really matter where it came from, as long as it's acquired legally. Oops, my apologies. So, like I said, the protections afforded by fair housing were won over time, and we've got a snapshot timeline here, beginning with the Civil Rights Act of 1866 and ending with Senate bills, or excuse me, primarily Senate Bill 205 passed in the end of December of 2024. So the Civil Rights Act of 1866 uh, was passed shortly after the end of the Civil War and the ratification of Amendments 13 and 14. Uh, this made newly freed slaves and native born Black Americans to be finally recognized as citizens. And the Civil Rights Act of 1866 details primarily the economic and property rights of these new citizens. And it includes explicit protections against abridging those rights on the basis of race or color. Pardon me. Of course, one act didn't eliminate all race or color based justice, and we would spend the next 100 years or so seeing various laws passed, Supreme Court decisions made that kept the project of securing the civil rights of the nation's newest citizens at the forefront of that political activism. So, in the 60s, despite the strides made by these activists in the civil rights movement, uh, especially of the mid 20th century, race based housing patterns persisted. So, for instance, while Black and Hispanic members of the US military were fighting and dying in Vietnam, their families here at home often struggled to rent or to purchase housing in residential areas because of their race, their color, religion, and their national origin. So, following intense pressure from organizations such as the NAACP and the GI Forum, as well as the pressure generated in the aftermath of the assassination of Martin Luther King Jr., uh, President Lyndon Baines Johnson acceded to the passage of the Civil Rights Act of 1968, and Title 8 of the Civil Rights Act of 1968 is what we now know as the Fair Housing Act. And that particular passage of the Act established race, color, national origin, and religion as protected classes. The Fair Housing Act, like any living bill, would be amended further, first in 1974 to add sex as a protected class, and then again in 1988 to add family and disability status as protected classes. In 2021, we saw Executive Order 13988 elaborate on the protected class of sex to explicitly include all sexual orientations and gender identities as a protected class. Uh, and here in Michigan, alongside the federal fair housing laws, as mentioned, state and local governments have passed their own fair housing laws. These laws can only expand and never curtail the protections afforded by the federal law. And the Elliott Larson's Civil Rights Act here in Michigan adds marital status and age protections in 1975. Later, the ELCRA, as the Elliott Larson Civil Rights Act is known, was amended in 2023 to mirror Executive Order 13988, and that added explicit protections for all sexual orientations and gender identities here in Michigan. Finally, on December 30th, 2024, Michigan Governor Gretchen Whitmer signed into law Senate Bill 205 of the 102nd Legislature, and that added fair housing protections based on source of income. A little more about source of income here. So by adding source of income protections, a landlord cannot discriminate if a tenant's income includes Section 8 housing vouchers, public assistance, veterans benefits, Social Security income, supplemental security income, other retirement programs, or really any other legally obtained source of income. So previously, 18 other states had laws that would bar landlords from rejecting tenants solely because of their housing vouchers. And additionally, 16 Michigan cities beat the state to the punch, previously adopting ordinances around source of income discrimination. The legislation also defines source of income within Michigan's Elliott Larson Civil Rights Act, meaning that renters are allowed to sue if they believe landlords are denying them housing of their source of income. Tenants can also file complaints with the Michigan Department of Civil Rights. So, relatedly, we've been asked the question before, what then of a person's credit score? It's not, of course, the same as one source of income. It could be seen as related, but a housing provider cannot have a facially neutral income or wealth requirement that is equally applied but has the effect of excluding populations with rental subsidies. So credit scores and credit history reports may not be valid indicators of whether a tenant will reliably pay the rent. So for example, there are cases where a vouchering agency would pay 100% of the rent, and therefore a credit history would be irrelevant. There are some more recent changes. So as of January 20th, 2025, federally, the protections of Executive Order 13988 will be curtailed. So federal law once more, as a protected class, recognizes only sex and not sexual orientation and gender identity. We'll continue to work to provide more information on this and other changes as we go through our future trainings. But again, that pertains to federal law here in Michigan. The ELCRA still holds. So when we talk about discrimination, there are several forms. There's discriminatory intent, which is the most bald-faced, which is an active intentional mistreatment of a person based on a protected class. There's disparate impact, which can be harder to see, and those are passive or facially neutral policies that have the effect of mistreating a protected class. There's retaliation, which is taking any negative action after a person asserts their fair housing rights. And then there's failure to accommodate, which pertains primarily to disability status, and that's just disallowing reasonable accommodations or modifications that will allow a person full use and enjoyment of their living space. So, like we said, there's the formula of a covered dwelling, a protected person, and unlawful practice. So only behavior that involves one or more of the protected classes is illegal under the Fair Housing Act. So for example, a landlord refuses to rent an apartment to a prospective tenant, um, and in that they have not at this point violated the act. It's a covered practice, refusal to rent in a covered property, an apartment building. Those are involved, but unless it can also be shown that the landlord's actions were based on the prospect's race, color, religion, sexual orientation or gender identity, disability, family status, or national origin, uh, it is not illegal under the Fair Housing Act. So if the landlord's action was based on another factor, uh, such as a prospect's particular a prospect's history of having manufactured illegal drugs, um, no violation of the act has occurred. However, the landlord in this example doesn't need to have been acting maliciously or otherwise with discriminatory intent. The practice is prohibited even if it has a disparate impact. Yeah, to say that again, that is, a practice can appear neutral or even beneficial, but because of how protected classes intersect with reality, could have a disparate impact affecting a protected class. So, as an illustration of that, let's say that a property developer wants to build affordable housing in the area that's specifically intended for occupation by nurses. Career is not a protected class, and so that should be above board or feels above board and maybe even noble, given that nurses work hard. However, in the developer's area, as it stands in this hypothetical, 95% of these nurses are white. So, by attempting to limit access to the dwelling only to the area's nurses, the developer has unintentionally limited access based on race. And this creates a disparate impact. So, retaliation is always out of bounds. Uh, let's say someone raises a fair housing complaint, even if that does not actually constitute an example of illegal housing discrimination, retaliating for raising that complaint does. Uh, excuse me, is illegal under the Fair Housing. And then, as I mentioned, failure to accommodate is a housing provider's failure to allow reasonable accommodations or modifications that better allow a disabled person to exercise their right to full use and enjoyment of the uh, That's one of the more common practices cited in fair housing complaints. However, it is not the focus of today's training. The focus of today's training is steering. So, what is steering? To understand what steering is and what it looks like, uh, we'll discuss the elements of a steering complaint. We'll examine some example phrases that could indicate steering. We'll briefly review a handful of legal cases where a defendant has been found, uh, excuse me, where steering has been alleged. I've written found guilty, but it's legally a strange um, difference there. Anyway, sorry. And finally, we'll look into an investigation by Newsday into the ways that some real estate agents in Long Island were trained and how this training can either perpetuate attitudes or fail to dispel prejudices that could themselves lead to steering. So, at a glance, though, steering typically takes the form of either discriminatory intent or disparate impact discrimination. Um, Although steering is our focus today, I want to take just a brief moment to relate it to two other segregatory practices. These are redlining and blockbusting. You may have heard of redlining before. Redlining is related to financial lending and is carried out by banks or other financial institutions. And blockbusting is related to market manipulation carried out by real estate agents. A full discussion of redlining and blockbusting really deserves its own training. And while all three practices serve to limit housing choice, steering is unique in that it does not necessarily involve financial gating. Redlining and blockbusting definitionally relate to finances. So we're going to focus on the third one here. And next, we'll talk about the necessary elements of steering. So there are two elements to a steering violation. The first is that there is an effort to influence a prospect's choice of a house or apartment. And the second element is that the housing provider's effort is related to the prospect's protected category. Notably, this effort to influence does not have to be malicious or result in injury in order to establish illegal steering. So, in other words, all steering is illegal even when it is well intentioned. There are many fair housing cases involving a housing provider who sincerely attempted to create a safer environment, a more comfortable environment for a family, tried to direct a non English speaking prospect to a neighborhood where they could easily communicate with their neighbors, uh, could be encouraging a person who uses a wheelchair to live on the first floor for their convenience. Um, these are all, however, instances of steering. So the general rule to follow is that it's up to the applicant to determine where they wish to live. And efforts by a housing provider to encourage, discourage, infer, or redirect a prospect because of their children, uh, their disability, their race, ethnicity, or any other protected characteristic. These are illegal acts of steering and are prohibited by the Fair Housing Act. So we at the center like to say that where you live affects how you live. This basically just means, again, a housing seeker should be able to choose within their means how they live. So we'll walk through some steering example statements here. These are taken from the Fair Housing Institute, so could be um, a little more illustrative than we'll see in real life. But prospects may be clear about their preferences up front, and that is often helpful in narrowing their housing search. However, a housing provider should never participate in assisting a prospect to locate an apartment or home in an area without people of a certain protected category. So, just as important as not discouraging or directing prospects based upon their improper requests, just as important as that is refusing to answer questions that relate in any way to a property's demographics. Um, so, for instance, responding to a prospect's questions about the percentage of Hispanic tenants, or the number of children in an area, the diversity of the crime statistics. These could all very well have the effect of encouraging the prospect and could be steering. Um, it could also have the opposite effect. And for liability purposes, a housing provider um, should understand that the motivation for a prospect's questions don't matter. It's just safer not to answer those. And if you, as a housing seeker, hear things like these example statements, it should raise some red flags. So the first one, since you have several children, our experience has shown that we will have fewer complaints from neighbors if you live on the first floor. It would be steering based on familial status. There's nothing saying that uh, um, your children will cause concern. That area of the property is viewed as our quiet area, so you should choose an apartment in a different area closer to other young families. Again, based on familial status. I just don't see you as fitting into this community. I'm sure I can find you a different property where you would be more comfortable. That's all over the place. It's unclear which protected class is at issue, but any are possible or likely. And then I'm not permitted to be a bigot in my work, but if you are, it's fine with me. Just tell me what you're looking for and I'll find it. It's pretty easy one here. If anybody says I'm not permitted to be a bigot, but it's likely that they're about to do or say something bigoted, and that is generally disallowed by the Fair Housing Act. A few more here. This property has a lot of Mexican Americans, so you should fit right in. That's steering based on national origin. I own several duplexes in this area. You'll probably feel more comfortable in one of my other duplexes. The key phrase there is you'll probably feel more comfortable. That is steering. I assume from the last name you are Jewish like me. I have a vacant apartment that is next door to another Jewish family. Would you like to see it? This is steering based on religion or potentially national origin. And the only available unit we have is on the second floor. And since I see that you use a wheelchair, I can put you on a wait list for a first floor unit. This is steering based on disability status. And to loop back to failure to accommodate, it's incumbent on the person with a disability to request that accommodation. Otherwise, in this case, it could be seen as steering. So again, these are all hypothetical statements generated by the Fair Housing Institute. Um, but we're going to take a look now to what steering looks like in reality. So we're going to do a little case review. We're going to look at a handful of court cases where steering was found to be at least one form of present discrimination. Uh, and these cases are, all of them are unfortunately from outside of Michigan. So they're not necessarily accountable to the same set of state protections. However, steering is disallowed federally. So they'll illustrate some common characteristics of steering, and they are all accountable to federal fair housing. And so, just as a reminder, as we get into this case review, we are not attorneys, and what follows is not legal advice. The first one we'll look at here is the U.S. versus Housing Authority of Ashland. Uh, the Housing Authority of Ashland maintains several public housing communities in Alabama. And so, on December 13th, 2022, the court entered a consent decree in the United States versus Housing Authority, and that follows a series of complaints alleging that the Ashland Housing Authority engaged in a pattern or practice of discrimination and that they were denying rights to a group of persons on the basis of race in violation of the Fair Housing Act by steering Black applicants away from their overwhelmingly white properties that it manages and steering white applicants away from two disproportionately Black properties that it manages. Now, these levels of segregation can't, the court found, be explained without discrimination. They couldn't make the numbers work by looking at income level, for instance. Uh, it's not clear whether whether these steering practices were undertaken on purpose or otherwise consciously, but that is not legally important. The Fair Housing Act prohibits steering whether it's intentional or not. So after the complaint was filed, the Housing Authority of Ashland denied wrongdoing, but pled no contest to the court's proposed remedies. That's why I tripped over the guilty earlier. Uh, so these remedies follow. The consent decree requires the defendants to pay $275,000 in damages to the 23 or current or former tenants who are named as plaintiffs. Pay a $10,000 civil penalty to the United States, and to implement policies and procedures to remedy the alleged segregation and to ensure non-discrimination, transparency, consistency in processing applications, and how they offer units to applicants. They are also enjoined to contact a group of approximately 145 individuals. Um, this group is disproportionately Black who applied to these white properties but were not placed on the waiting list for those properties, and to offer them spots on those waiting lists based on their original dates of application. And finally, to undergo fair housing training and submit periodic compliance reports to the Justice Department. So steering has a cost. The next case is US versus Crimson Management. They maintain at least two properties for elderly and disabled tenants in Georgia. Cedarwood Village is the quote unquote desirable property, and Cedartown Commons is the less desirable. So Crimson Management routinely and disproportionately sent their Black applicants to Cedartown Commons, where the surroundings were abandoned houses, not much landscaping to speak of, not a lot of amenities nearby. Um, the reason I include this case is that it should also illustrate how steering can intersect with other types of discrimination. So it's seldom the case, if ever, that the two or more properties at issue in a steering case are, aside from their racial, religious, or other protected class composition, completely equal. The underlying reasons and history of why that pattern persists is beyond the scope of this training, of course, but it is often the case that those who fit into the marginalized population of a protected class are steered into less desirable subsets of housing. So the methods by which steering occurs need not be a statement made by a realtor or agent, as we saw earlier. Nobody needs to explicitly say, you'll be more comfortable over here. It can be quiet or procedural steering. That's accomplished by the misuse of, say, ordered applicant lists or other management tools. So in this case, Crimson Management, the property managers had full individual control and discretion to manually edit applicant priority and unit assignment. So that's well outside of best practices suggested by the U.S. Department of Agriculture or HUD. Uh, Much like in the first case, these disparities also cannot, the complaint alleges, be described by non-discriminatory factors such as income. So as stated in the complaint, all the elderly or disabled individuals who applied for apartments at Cedarwood Village and Cedartown Commons from 2012 to 2018 qualified as very low income. So that's to say that even when controlling for non-discriminatory variables like income, the race-based differences in tenant concentration persists at a significant level. Another way to say that, it's steering. So I'm going to, for time consideration, skip this next case here. And we're going to get into our Newsday investigation. So Newsday is a daily newspaper that serves Nassau and Suffolk County in New York, so Long Island. And in 2019, they put together a rather large investigation, including 86 paired tests that they used to investigate potential steering in Long Island. Now, the article itself is available online. Um, I will, however, focus on their investigation of training sessions given to realtors and other agents associated with realty, given by the Long Island Board of Realtors or LIBOR, and to see how these practices, these steering practices, may be institutionally perpetuated. So, to start, New York State does require continuing education for its realtors. That's a pretty standard practice in any state. The Newsday reporters attended 6 trainings hosted by the Long Island Board of Realtors. They found, um, when they showed their results to fair housing experts, that 5 of these 6 trainings failed to address fair housing comprehensively. Um, and, and one instructor likened fair housing to speed limits, saying, you get to choose whether you break the law. And of course, that's bad advice. And I just, at the top here, want to say that this section is not intended to disparage realtors or realty training on the whole. Within the investigation, though, we'll see where some of the attitudes that could result in steering, they're not properly examined or discarded. We'll also see that the fair housing education that may help agents to abridge those attitudes or just otherwise to avoid steering, thanks to the greater awareness afforded by that education, is insufficient. So that said, the some of the instructors in these trainings spent time giving their review of television programs. Some described funeral rituals. And in only one of the 6 trainings, and that was presented by the former Long Island Board of Realtors president, Nicholas Gigante, covered the mandated 3 hours of fair housing content. Another instructor, in contrast, spent 20 minutes instead of 3 hours talking about fair housing, which is not enough. Newsday reporters did record the following from this instructor, and here is where I would play for you a voice clip from Diane Scalza. Unfortunately, I work in fair housing and not IT, so there were some hiccups. But so even a statement such as, that's so lily white, it's not even funny, like where I live in White Islip. This is Diane Scalza, who is one of their real estate instructors, talking about where she lives in Long Island, a place called West Islip. But because of the concentration of white people there, they call it White Islip. Now, this too, steering is steering regardless of whether it's happening to a majority or minority member of a protected class. So even pushing more and more white people into West Islip is steering and is prohibited by the Fair Housing. And finally, with this Newsday investigation, I just want to read directly from the article here. An attorney and former real estate broker, Kathleen Nolan, is a former LIBOR president and answers a LIBOR legal helpline for agents and brokers. She taught an all-day class in November that primarily focused on commercial real estate transactions involving investment properties. The course documents said that Nolan would cover 3 hours of fair housing instruction. She spoke about the topic for a period of less than 45 minutes, and that 45 minutes included 4 minutes devoted to stories about her mother's misadventures in cars, 4 minutes given to her grandmother's military service during World War I, television shows such as Amazon's The Man in the High Castle, Showtime's The Handmaid's Tale, and the Fox series The Americans, and 7 minutes focused on the so-called comfort animals that qualified renters may house in apartments. So while those are all good shows, none of them are germane to fair housing. And finally, for our purposes today, when discussing steering, Nolan said, steering is when you decide where somebody has to live based on how he looks, the church he attends, all kinds of different things, all protected classes. And that was the extent of the training on steering. So granted, this educator deals primarily with commercial real estate transactions, and it's possible that that expertise means that they've mostly dealt in the sale and purchase of, office suites, restaurant sites, and those would not be considered dwellings and therefore would not be covered by fair housing. However, apartment buildings of sufficient size can be considered commercial properties and would be considered dwellings. So this person should be covering steering. And while this trainer is not necessarily encouraging steering or other discriminatory practices, the instruction here is certainly insufficient to properly educate realtors or their associated agents on the fair housing law, and to educate them out of prejudices that might cause steering. So steering doesn't have one particular look or flavor. There are, however, easy ways to avoid it, and that's these best practices. During tenant application and screening, housing providers should treat all applicants fairly, equally, and honestly. Follow the same application and screening processes for every applicant. Never tell an applicant that a dwelling is not available when it is. Tell all applicants about all available units, and sell the property, not the person. So these are the basics of what a tenant should expect when applying for an apartment. So if tenants aren't treated fairly or are turned away for what they believe is an illegal reason under the fair housing laws, they should contact a fair housing center or enforcement agency as soon as they can. And what I mean when I say selling the property is that a housing provider can avoid falling afoul of fair housing law by sticking to facts about the properties like amenities nearby, square footage, etc. Avoid selling based on assumed or declared aspects of the prospect's personality or characteristics. So, if, for instance, a housing seeker asks about school districts, this is a common steering pitfall. A housing provider or agent can, instead of offering their own opinion on which districts are good or bad, simply point the seeker to an objective source of information that lists school districts in the area. That way, they haven't encouraged or discouraged a prospect one way or the other, and have done their best to avoid screening that prospect, or steering that prospect. So a fair housing adherent provider will treat everyone the same. They will allow housing seekers to make their own choices, and they will make decisions based on an applicant's behavior, not an applicant's characteristics. 3 easy rules that a fair housing provider can follow. And it looks like I did have a little more time, because that brings us to these resources that we've used to compile this today. The Department of Housing and Urban Development website, HUD.gov, is a great resource for some of the more ins and outs of fair housing law. The Fair Housing Act as amended, if you like reading bills, is great for that. The Elliott Larson Civil Rights Act here in Michigan is very similar to the Fair Housing Act, but adds quite a bit more. And then as far as some of the more interpretive resources, The Fair Housing Institute is a great resource. Justia is good for court case digestions. The Civil Rights Division through the U.S. Department of Justice uh, is another good resource for those court cases. And then finally, Newsday for that article or that investigations article is a great read. So now I would like to thank you all again for coming. Um, Again, we are the Fair Housing Center of Southwest Michigan here in downtown Zoo. Please contact us by phone or online if you have fair housing questions. I believe this is where we'll stop the recording and I will open up the floor to any questions.